Yeah, good afternoon again. Yeah, so sorry about that. My video got disconnected, and I had to start another session. So I'll edit the videos and join them together before I post them. But so where was I? Yes. So the motion to recuse, right? Um, so yeah. So in one of the filings that I made, in one of the, I think it was in the appellate court, in my arguments, I said something to the effect that the judge was how did I call it? The judge was immune to recusal, basically. He could not be, that he could not be recused, implying that I thought that because I filed that motion and was denied, it could not be filed again, right? That was an intentional thing that I did to make Morgan Hybner believe that I was in this, that I had this belief, right? That I was out of options, and but I knew that because of the mountain of new events, I could ask for a second. I could have a second shot at it, right? Because I have the right to show the new evidence, right, of bias and unequal treatment before the court. So I had that in my back pocket, right? So I deployed that today. Actually, last night, I filed a second motion to recuse, and I included as exhibits different things, right? One, I included the opinion emitted by the first appellate court, saying that my petition for a writ of mandamus was a moot point. It was moot, right? And all the pending motions were moot. I also included an email in which, and a letter, an official letter that I sent to the clerk, asking the clerk of the 387 to send me the orders that the judge signed, because the first appellate court is saying that the judge signed the orders, and I haven't received any orders. And I asked my former partner, and she told me that she hasn't received any orders either. So I sent this through two different channels. I filed a notice in the 387th in the case. And that notice, it wasn't a notice. It was a no-fee document, it's called, right? It's a special type of filing code. I filed this letter, and I addressed it to the clerk. So I added the clerk, basically, as a recipient in the e-service section, right, of the case, in the envelope, right? So she received this. She was served electronically with this letter, right? This is a legal document that says that she received this, right? And this is important. It's going to be important in a minute. I also sent an email from my personal email to Morgan Hybner, Tina Simon, the clerk, sending the same letter, asking to give me the orders that were supposedly signed on October 10th, right, according to the docket summary. And I attached the docket summary showing that it says notice of entry. Notice of entry means this is a communication to tell everybody that we are entering these orders, right, into the record. So it says notice of entry dash temporary orders. It's pretty clear that it means that there were orders entered, right? Which justifies what the appellate court said in their opinion, right? This is a moot point because these orders were entered. Now, interestingly, that no-fee document that I filed, when you file things on the e-filing system that this court uses, which is Tyler Tech is the brand, there's 3 steps or 3 phases on the filing. When you submit the envelope, so you create an envelope with the parties and the e-server's contacts and the files that you're going to send, all that, right? You hit submit, and then the service goes out, and you get an email for that. Then you get a subsequent email that says document or filing submitted, right? It means that it's submitted to the clerk for review and approval eventually, right? That is going to actually be filed. And then there's a 3rd step, which is the last confirmation that says, it's another email that says filing accepted, right? And the envelope number, meaning you completed all the steps and this document is now part of the docket, right? It will appear in the docket summary. So interestingly, this communication that I filed I think is the only document in the history of this case, which has more than 90 entries at this point, is the only one that did not get to the 3rd stage. At least when last time I checked, it hadn't, right? So this means the document got submitted, right, by Tyler Tech to the clerk. The clerk was notified, but the clerk did not accept the document, right? So it doesn't become part of the record, right? And this is the document where I'm asking the clerk to give me the orders, the supposed orders that caused the First Appellate Court to deny my petition for the writ of mandamus without addressing the substance of the petition, right? Well, it was a procedural dismissal. So the clerk does not accept the filing, or hasn't, right, until I check. And it's been 2 days, right? Typically, all the filings that I do are accepted within 4 business hours. I can show the stats of this. I have the numbers, right? This one, after 2 days, still pending, right? Okay. But I also remember, I sent the email directly to Morgan Hybner, and none of them replied. I mean, the logical thing, right? If you're seeing that you are litigating a case with a pro se litigant, and he's under the impression that orders were entered, and you know that they weren't, the logical and moral, and I think maybe an obligation you have, because you are the petitioner, you're representing the petitioner, you have to tell that person there are no orders entered. No orders have been entered. You have to tell them the truth, right? I think you have that obligation. You can't let them be ignorant of the situation when you know that what they're thinking is not right. None of them replied. Morgan Hybner did not reply, Tina Simon did not reply, and the clerk did not reply. And I understand Morgan Hybner is representing the other party, but the clerk has an obligation to reply. I imagine, right? If and I'm pointing to the error, right? I'm pointing to index 81 in the docket that says that orders were entered, and she knows that orders are not entered, right? And she's not replying to the email. So they're keeping me in the dark. So I cannot seek relief in another place, right? In another court. And the interesting thing about is in the case of Morgan Hybner with this email is the contrast with her other emails. There's been multiple instances in which Morgan Hybner has sent me emails. I mean, and I'm the opposing party, right? Yes, I'm a private citizen. I'm not an attorney, but I'm acting pro se. I'm representing myself. She has to treat me as if I was an attorney, right? In that sense, she has to give me the same courtesy she would give an attorney because I'm representing myself. So there's been multiple instances, and I have, I'm not going to show you the emails, but there's been multiple instances in which I file a document and Morgan Hybner corrects me. She sends me an email immediately saying, hey, don't do this, or don't file these kind of things. She instructs me on things that she thinks I should not do, right? Which is, I mean, I'm the opposing party, right? She should let me conduct my own defense in the way that I see fit. And if I make a mistake, it's my interest that's going to be harmed, right? She shouldn't be trying to give me legal advice and directing my legal defense, right, and my actions. Right? That's at least is questionable, right? Because there's a conflict of interest. She could tell me things that could mislead me to make a mistake, right? Or that would hide things that she's doing that are, could even be illegal, right? But because she has an interest in hiding them, like this notice that I'm going to talk about, then she will direct me to not file things in the court, right? It's another way of obstructing justice, right? Like trying to trick the other party into not filing things that would expose what she's doing, right? So, but beyond that, right? Besides that, the point I'm trying to convey is that there's been multiple instances in which she has taken the step of emailing me unsolicited emails. I'm not asking her for her opinion, but she emails me telling me what to do, right? But now that I'm asking about these temporary orders that are in the docket summary, and she knows they're not temporary orders because she said that on the record today, and she's not telling me, right? So there you can see the bad faith, right? You can see the bad faith, the design of this, and the premeditation. So it's, it's just the behavior, right? After the fact shows culpability, right? Now, and that's my opinion, right? I'm not the FBI, but I think it shows that, they don't want to say anything that could either lead me to the resolution of the puzzle or incriminate themselves, right? So yeah, so they didn't reply to the email, okay? And now I'm going to talk a little bit about how I use technology to figure it out, right? In the previous session, I described the inference that I could see in the pipeline, right? And I described the different scenarios. Like I said something like, well, maybe the judge signed the orders, right? But the pipeline picked up that these supposed orders, this notice of entries, right, had only 3 pages. And if it was a notice of entry for the temporary orders, it should include the temporary orders being entered, right, logically. And Morgan Hybner's orders, fraudulent orders, proposed orders, had 30-something pages, right? So it could not be that. Mine had 2 pages, 1.5, so it could be mine, but I doubt it. And also, the pipeline flagged that for the judge to sign the orders, they have to be proposed by a party and signed by the other as, I reviewed this and I don't have any obvious disagreement with this, right? Like I can agree that I, saw this and it sounds to me like what the judge said, right? And I said in writing in multiple filings that I do not agree with the drafts, right? So if the judge has discretion to sign it either way, right? But I'm not saying that he needs my approval, right? He can sign them, but it probably would be grounds for appeal or something, right? I don't know. I have to check in the pipeline what will be the consequence of that. But it's not a common procedure, right? That the judge signs the order without the 2 parties have been in agreement that what it's in the draft is what the judge said, right? Because to avoid what Morgan Hybner is doing, basically, right? So anyhow, the hypothesis was that maybe he didn't sign the orders, right? Maybe this document is something else. It's a clerical error, or it's that was the theory, right? So anyhow, I went this morning, right, to file. I filed the motion to recuse last night, but I went a little bit early, and I also filed it in person because remember, the clerk has not accepted my envelope in 2 days, and I anticipated that maybe the clerk could find a reason to reject my electronic filing of yesterday, and then, oops, there's no motion to recuse, right? And my check move made would have been disabled. So what I did, I went in person, I filed it in paper, right? Which they are obligated to receive it. They can't say no unless there's a fatal flaw in the document, which there wasn't. So I went in a little bit earlier and I filed it in person. Success, right? As I'm there, it occurred to me, well, let's solve this mystery right here. And I asked the person in the clerk's office, could you please give me a copy of the document index 81? This notice of entry, temporary orders that ultimately caused the appellate court to deny my petition for writ of mandamus. The person prints the document and stamps it and signs it, the copy, right? That is a certified copy, and puts the time, 8:42 a.m. When I see the document, I said, bingo, I got her. So the document is, and let me show you, right? Sorry about that. Okay, so this is the document index 81 in the docket. That is the notice of entry dash, this is how it appears, right? Notice of entry dash temporary orders. Right? Now, when you open the document, and I'm going to increase it so you can see, right? So look, the document, this document was filed on Friday, right? On that Friday. So it says notice of entry dash temporary orders. Exactly what it says in the document, right? And then But look at the wording of what this says. It says, notice is hereby given that notice of entry for temporary orders. So they inserted that 4. They changed the dash in the title for a 4. Temporary orders will be considered by the court in person on October 16th. So what this really is a notice of hearing, right? So this is really a notice of hearing. It's a document telling you have to come in person because we're going to discuss this, right? And file your exhibits and do everything that you need to do. But that would be a notice of hearing. And Morgan Hybner had sent me multiple notice of hearings in the past, right, to harass me. But she knows that the document, I'm saying this because they're in the record. So she and Tina Simon, they both know that the document should be called notice of hearing. So they changed the title of the document to make it look like these were orders, or that this was a notice that orders were entered into the record, right? Which is not true. What he's saying is that the notice of entry for temporary orders will be considered, which really doesn't make much sense. I mean, what is going to be considered is the draft, right? That's of the proposed orders, but the notice of entry, how can the notice of entry be considered if nothing has been entered yet? We don't have an agreement on the draft. I mean, this makes no sense, right? But it's a document intentionally written in this way to justify that, how do you call that? It's a title, right, in the document designed to mislead you. That misleading title, right, to justify that the clerk put that in the docket, and that caused the appellate court to deny my petition of mandamus. Right, so mystery solved. The way they did it was mistitling, or putting a title that is misleading in a document that's not the purpose of the document, just to do this. And another data point is that this is, I don't know if they can go deeper, right, in this whole. This hearing was set up, remember, on the 10th. In that hearing, that was heavily or highly contentious, right? And in that hearing, when they're setting up the you can hear the negotiation, right, of the time, and Morgan Hybner recites her schedule, and she has trials, all these things, right? And at the end, they set on a time and a date, and we are there to convey, okay? We agree to convey. Now, what's interesting is that this same dynamic has happened in the past in the record, right, in the previous hearings. And every time this happens, that during a hearing, a next hearing is scheduled at the end, right? Like, let's continue this conversation on Friday. Like when the example was September 8th, they scheduled in the hearing another hearing for September 11th, leaving me only 2 days to respond, which would be inappropriate notice, right? This is the TTP that we described before. But this scheduling happened inside the first meeting, right? The first hearing. And in all the instances that this has happened, Morgan Hybner has never sent me a notice about the hearing. In fact, in one occasion, I asked her, are we going to have that hearing? Like, you haven't sent me a notice. And she said, I don't have to send you a notice because this was already said by the judge, and his word, like the fact that he verbally said, come here on Friday, that is a notice on itself. I don't have to give you a notice. This is what she told me, right? When this happened after the September 8th hearing. But now, for this one, she did send me a notice, right? I mean, it's a different behavior. Why she sent me a notice for this one, but not for the previous ones, right? For all the other hearings that fall into this category that they were scheduled in another hearing, at the end of another hearing, she has never sent me a notice. But for this one, she did. And she put a title in the notice that would be misleading to the First Appellate Court. So the First Appellate Court would deny the writ of mandamus, right? So I anticipated, right, using the pipeline, the legal vaccine yesterday, that this was likely the case. But, the system didn't have confidence if it would be a clerical error or would be a fraudulent document. This is the fraudulent document, right? Like, it's a document which title is not what the document is about, and is worded in a way to sound like it could be right, but obviously this is misleading, right? It doesn't say hearing anywhere, right? And what was going to take place today was a hearing to talk about the proposed orders, right? That Morgan Hybner had, and then I also had. We also had my proposed orders to talk about. But she titled the document in this way, right, to make it look like orders were entered. But this is where it gets interesting, right? Because the pipeline, the legal vaccine, you know, in the debug output, I'm going to paraphrase what it says, right? The implications of this, right? So, first of all, this is obstruction to access to the state courts. She's by doing this, she's obstructing my access to the appellate court. She is doing something that caused the petition for the writ of mandamus to be denied. And that killed my access to justice. Like, that killed the possibility to be heard in a higher court and get review of what they're doing in this lower court, right? So it's obstruction. She's obstructing my access to the state courts. So, you know, because of that, I had already pre-drafted a notice to file in the federal court to inform the judge that she's doing this, right? And I had already attached the docket summary. I didn't know the mechanism, right? But I knew that this is what was happening, right? So I had the document already printed when I went to court this morning, to the state court, right? To the 387th. I had the document printed, and when I find this, I attached it, and then I went to the federal court and I filed it, right? I filed the notice of obstruction to the state court system, right? With the federal court. And this is attached in there, and the docket summary. You know, in the notice, I didn't like go into the details of the mechanics of the ruse. This is a ruse. This is really deception, right? Deception against me, the child, and the appellate court, right? She is deceiving all of us. But what I was going to say, right? Because, you know, and this is the part that I don't know how to calibrate, right? Because I've never done this before, and I don't know what is the appropriate level of detail, right? For a notice of this type to a judge in the federal court, I don't know, right? But, you know, so, and I had different drafts, right, that I could file with different levels of detail, right? Like from like little detail to going into details of the mechanics on how this was done, right? But at the end, I settled on the one with less detail. And I want to say my reasoning here, in case this becomes relevant at some point. My reasoning was that a judge that is a judge in a federal court has to be a very sophisticated lawyer. I mean, because this person has to have seen pretty much everything there is to see, right? In terms of these kind of tricks. So, you know, it's not my job to tell him. I mean, if I can say it, I guess what I'm trying to say is that if I could say it, right? And I have been exposed to this industry, to this professional circle for 4 months, maybe out of necessity, but 4 months, all in all, right? I've never been sued before in my life. I said this before. So if only after 4 months of exposure, I see this and it's obvious to me what happened, right? There is no need for me to spell it out, right? In a federal filing, like just showing the documents, like I'm pretty sure this judge will see what she's doing, right? So now that's in the federal court. The other thing that is interesting on the pipeline output is the potential implications of this, right? And here, I don't know, like, let me say this, right? Let me stop presenting. Oh, and before I do that, let me show you this, right? So it's very clear, because they're gonna say it was a clerical mistake on their side, right? Like, oh, you know, the Adams law firm made a mistake. But you know, what a coincidence that this mistake, coincidentally, killed my petition of mandamus, right, in the appellate court, which is exactly what they needed to not, you know, to avoid all the bad things that we discussed before. So it's such a coincidence, right, that they made the mistake, right? But the other thing that is interesting to me is, so, well, look at this page, right? So she signed this, right? her name and her signature is on this, right? And she said that this was served on October 10th, right? And there is a certificate, there is even a printout of this, it says that that I was served, and I have to tell you, So it says that it was at 2:45 p.m. I checked my records. I can't find this email. I have to double check, right? I will check my records and I will double check it. So far, I haven't been able to find this list of service, right? So I don't know. I'm not going to drive any conclusions on that, but I will investigate this further on my side. I will see if I really have that email. Yes. So what I was saying, right? The pipeline has a lot of hypertuning parameters, right, that I can tweak, right, that I built into it. And let me close this window to make this go a little bit faster, right? 1 second. Okay. Like I run experiments with the hyperparameters, right? Because they change the quality and the aggressiveness of the pipeline. So what I'm going to say, I don't know, because I have no baseline on the on that side of the legal. I've only been exposed to a very narrow segment of the legal field, right, through this process. But the pipeline thinks that what Morgan Hybner did with this could, right? I don't know if this is true. Like I need, and please, when Venezuelan informant, I'm talking to you, please check with a competent lawyer to see if this is the case, right? Because if this is the case, please tell me. I would love to action on this, right? But the pipeline thinks that this could amount to child endangerment. Why? Because, and here I'm paraphrasing the output, right? I'm translating something that is an output that is designed for an engineer to read into, human understandable language. But the insight is that assume for a second, right, that they did this, right? Let's get out of the discussion of whether they did it or not, but for a second, right? Assume hypothetically that this was intentional, right? That this document was created intentionally with that title to cause the denial of the petition for the writ of mandamus, right? Which in turn caused the dismissal for the temporary restraining order to protect the child from the unsafe tires, right? Without the court addressing the substance of the request for the motion for the temporary restraining order. So if this document was designed intentionally, and that was the chain of events that happened, that child was put in danger because the court that could have taken an action was blindsided, right? Intentionally. Right? They were tricked into issuing an opinion by giving them false information or misleading information, which resulted in that temporary restraining order never being issued, which would have protected the child, right? So designing that document is according to the pipeline with the parameters that I have, right, set up right now, which I've run tons of A/B testing experiments, and these are the best parameters that I have, found so far, right? If I tune it further and I succeed in making it better, it could produce better results, right? But so far, this is the best setup that I have. It thinks that this could be interpreted as child endangerment, which I imagine would be a very serious thing for a lawyer that works supposedly to protect children, right? So I don't know. It feels like I don't know. It's amazing, right? Seeing that I can use technology to predict, what I need to do before I find the evidence, right? I mean, I didn't have that document because they set the document as private. That's the other thing, right? So in other documents, Morgan Hybner's, right? And this, I think, right, when eventually somebody makes the case, right? It's not my job to make the case. Like somebody, a prosecutor from imagine the DOJ or something, eventually, right? We'll look at this and we'll make a case. So all the documents that Morgan Hybner files, they mark them as private, right? Like in this document, not all of them, some of them, right? So this order, they marked it as private, and they don't redact anything. And the idea is that nobody can download the document, right, from the website of the court. To further the scheme, like to make it less likely to be discovered. But like if you put everything in context, right, like the refusal to tell me that there were no orders, right, that I was misled, as was the first appellate court, right? We were all misled by this misleading title. And then, they refused to tell me, both Morgan Hybner and Tina Simon, and also the clerk. None of them told me that there were no orders in a timely fashion, right? Maybe they will tell me now in the afternoon, right, after they see this video. But I don't know. And that causing, coincidentally, right, that document causing the consequence of the petition of mandamus being denied on procedural basis because the orders were supposedly signed, right, according to the title of this document. And making so that the appellate court did not even review the merits or address the merit or assess the merits of the motion for the temporary restraining order to protect the child from imminent danger, right? I think it's a very serious thing. But now, like another thing that is, and this is more an observation, right? This doesn't come from the pipeline, but it's an observation, just logical, right? It's interesting to me because if you think about it, right, and I think I touched on this on the previous session, there might have been multiple ways to accomplish the same goal. Like if this is something that they wanted to do, right, there will be multiple ways, right, to do it. And I discussed about the multiple ways that I see before, like, involving a person at the clerk's office or involving a person, like there's different ways that you could have accomplished exactly the same goal. But they choose to accomplish it with Morgan Hybner. And I think that on itself is very interesting. I mean, the fact that the decision was that the person that would sign this document with the misleading title to cause all this would be Morgan Hybner, right? And here, I don't know. I mean, I have to run this right through the pipeline to see what could be the potential reasoning of this, right? Like the reason behind this. Is it because, okay, say that they went a different route, okay, and they did it with a person at the clerk office, hypothetically, right? See what was the level of liability in that scenario. So if it's a person at the clerk's office, right, and the thing is discovered, then there's involvement of the state apparatus, right, which is a more serious claim, right? The consequences are higher. So it could be due to that, right? It could be due to, well, just Morgan Hybner is a private person, and if things come to head, it's just a private citizen, right? And the institution, the Fort Bend County, or I don't know, the court, 387, like doesn't get sued. I don't know. I don't know. I have to run this through the pipeline to see why, right? Or if it is that they see that she has the higher liability already, and she would be more likely to agree, right, to do this. Or if she's a scapegoat, right? Like, if it gets discovered, let's put it all on her. Right? I don't know. But I imagine, right, there must be a legal reason, because all this is based on legal concepts, right? There must be a legal reason behind the choice of executing this via Morgan Hybner. I just have to run the pipeline to see if I can find, what is the more likely thing, right? So yeah, so that's the situation, right? So when I went to the hearing this morning, I expressed when they read the docket that I had filed. Oh, and this is the other thing, right? So Morgan Hybner. So they're calling the dockets of the day, right at the beginning. And I stand up and I said, good morning, Your Honor. I'm Reinaldo Aguiar, Rosé, and I filed a motion to recuse. And according to the procedure, the Texas rules of civil procedure, all matters are stayed, right? And the judge was respectful, like he respected, like he didn't try to push, right, to get me to engage, right? But what is interesting is that Morgan Hybner immediately responded, and she said, Your Honor, he's filed a motion to recuse. No, in fact, she said it before I did, right? The first thing she said was, Your Honor, there was a motion to recuse filed last night, a second one, like making this face, right? And a motion for a temporary, like making it sound like I'm a crazy litigant, right? Like I'm bombarding her with motions that are crazy, right? And then she says, and this is critical, I think this is critical. She says, and Your Honor, that motion to recuse is based on something that did not happen, right? And this is a critical error for multiple reasons. I'm going to tell you I have to run this through the pipeline, but I'm going to tell you off the top of my head the multiple things that I see here. One is that the motion to recuse is not up for debate. Like it's a mandatory. Like if a person says motion to recuse, it has to be assessed, right, by the court, and if the judge doesn't want to recuse himself or themselves, it has to be reviewed by the administrative judge, right? This is not a motion against Morgan Hybner or the petitioner. She has nothing to say on this matter, right? This is about the judge, right? But she jumps and says on the record that the motion to recuse is based on things that never happened. So she's effectively, when she's doing this, she's transitioning, legally speaking, right? She's transitioning from defending the petitioner to defending the judge, because the motion to recuse is against the judge, right? And if she's attacking the merits of the motion to recuse, which she shouldn't have, right? At that point, after I said that, the matter should be stayed, right, until this is resolved. But she goes on to attack the motion, and it's a motion that is not directed at her or her client. So what business does she have defending the judge? And crucially, when she makes the statement that this is something that never happened, how does she know? She's not the judge. She didn't sign the orders. How does she know that the judge did not sign the orders on the 10th, as the docket says? So how does she know better than the judge whether he signed or not on the 10th is the question, right? This shows that she knows. She knows that the judge didn't sign. And the reason she knows is because she created this document, right, to make it look that way. Because otherwise she would have the doubt, as everybody has the doubt, right? I have the doubt. The First Appellate Court has the doubt, right? We are all believing that the judge signed the order. She should be believing that the judge signed the order as well. I mean, how is that she's the only person that is sure that this is not what happened, right? It's incredible. I mean, she either has special powers, right? She can read the mind of the judge and see inside his memories. Or she knows something. I don't know, the judge told her something. Like, how does she know that the judge didn't sign? But the most telling thing is that transition from being the lawyer of the petitioner to being the lawyer of the judge, right? That is the most astonishing thing to see, right? When she shouldn't have said anything, because, well, first of all, the motion is not directed at her or her client, and secondly, there is a rule of civil procedure that says that, after this motion is filed, there's nothing to discuss until this is addressed, right? And this is why this is a checkmate move that I was describing, because remember, like, they delayed this process so much, right, that at this point, these are temporary orders that the judge is on the record saying that last for 60 days since September 11th. So they're set to expire on November. I have to count the dates, right? Because some months have 31, But let's say that they expire on November 10th for the sake of the argument, right? So we're talking about 3 weeks from now. So in the current state, right, when I filed that motion to recuse, remember, the previous motion to recuse took from July 2nd to July 23rd, I think. So it was like 21 days, right, for the matter to be decided, and it was a much simpler motion, right, much simpler. You read the 2 motions to recuse, and that one was, was a piece of cake. This is way more complex because there's allegations of fraud against not against the judge, but in the case, like the judge has to review the entire docket, right, and see what Morgan Hybner said and the draft. Like she has to review, to see whether the decisions made by the judge were biased or not. I imagine, right, that would be a serious process of review, right, and because of the amount of documents that Morgan Hybner have filed, each draft being 36 pages or more, right, the judge has to read all 200 pages of drafts of Morgan Hybner to see if the ruling regarding the draft and the notices, and it's going to be a process that is going to take longer than the previous one, just by pure logic, right? Because more time has passed and more documents are going into the docket, right? And she needs to review whether the judge is biased or not. Or actually, no, let me rephrase. She has to review whether it could be perceived that the judge could be biased, right? She's not going to make a determination on bias. She's going to make a determination on potential for perception of bias, right? To assure due process. So if that took, the logic is, if that took 23 days, this should take at least 2 months, right? I imagine, right? And remember, the orders are set to expire in 21 days. So from the perspective of Morgan Hybner, right, this would be a perfect situation. She should be happy about this. Why? Well, because she's in a situation in which the orders are not signed, are verbal, and I still have to follow them. I mean, I'm still stripped from my parental rights because the verbal order is in place, right? Which is what she wanted. She wanted those orders to be enforceable, right? And they are enforceable. So she's getting everything her client wants, supposedly, right? And I cannot appeal them because they're not signed, right? So she's getting all the benefits and none of the downside. Nothing. There's no downside. So she should be ecstatic about this situation. It's the perfect scenario for her client. But Morgan Hybner is not happy. Morgan Hybner is complaining on the record about this motion and trying to criticize the motion when it's not directed at her or her client, right? What this tells you is that the true motivation of the litigation is not the safety of the child, right? It is to harass the other parent, right? To harass me in this case, right? Because that's why she needs the order signed, because she needs the orders to be in the record to call me crazy in federal court, right? That's the purpose, to discredit me. And that's why she had to put those clauses about international kidnapping and all those things. But if she doesn't have the order signed, she cannot use it in the federal court, right? So that's why she's unhappy. But that's why she is criticizing the motion to recuse. Any competent lawyer would smile in this situation where I'm filing this motion to recuse and there's only 3 weeks left in the orders, because it means that the orders are not going to be appealed, right? They're not going to be contested, and nobody's going to come back and say, Morgan Hybner, you did this wrong or you did that wrong, right? Because there's not going to be any appellate review on these orders because they're verbal. I cannot appeal them, right? So if you think about it logically, she should be happy about the motion to recuse, but she's obviously not, and you can hear that on the record today, right? She started saying that the orders, that the motion to recuse is based on something that didn't happen, and she wanted to start explaining what really happened. Like she was eager to explain, right? But the judge just stopped her, said, hey, he filed his motion to recuse, we have to review it and come back with an answer. So I mean, I think the judge, respects for that is what I'm trying to say. But Morgan Hybner was obviously not happy about the motion to recuse. And also, she sent me an email saying that I've been filing too many motions. Again, like this is an example of Morgan Hybner sending me emails to direct my litigation strategy, right? This was, I think, yesterday, I don't know. But I think it's seeding a narrative. I think it's a way to see the narrative that the petitioner is going to run out of money, and that's why we're going to back down. right? It's not because this is wrong or because you're not crazy. It's because you are filing so many motions that the petitioner is going to run out of money, and we're going to have to, withdraw the lawsuit because we run out of money, right? It could be that, right? I don't know. But super interesting developments. So I think I'm going to close this session for now. And I'll make another, I'll plan for the technical session there, because the things are piling up and I haven't been able to do them. Well, thank you so much for your time, and I'll see you in the next one.